Okay, people, this is Paul Whipple making a short video to present to you some of our evidence that we've tried to report to officials, which some were allowed. For example, this is a packet. It's sealed. I'm going to open it. We served the same thing to the Sullivan County Sheriff, who did in good faith acknowledge and receive it and gave us a stamp. And which we also presented to Sergeant Aaron Waterman, Newport Police, on body cam the day before this, so I believe it was April 13th. And he said it would be state police jurisdiction. So even though we were attesting that the actions and false statements occurred in Newport, he said they originated in Croydon. So it would be state police. So we called the state police and were told that they would contact us the next day, that the officer handling the matter was not in that day. So he did not contact us the next day as promised, or any day since. So he did send an email to David Keith that they've done an investigation and found that no defamation occurred. So I'm going to present what evidence they refused to act on. There's my statement that I, a man and member of the people of Croydon, New Hampshire, above age of majority and of sound mind, body, spirit, without disability, in the faith of the Son of God, who dwells in me, and according to the new will and testament, ratified in blood upon the death of the testator. That means that no man can set it aside, annul it, or add conditions to it, which these have all effectively nullified the will of God, the faith, the Son of God, the truth, and the people's right to walk in truth. Therefore, I am duty-bound to report trespasses against me, my person, and he who lives in me, by covenant. To wit, Paul Michael Freitas, Croydon clerk and tax collector, has borne false witness, and of course by now his husband has added his name to that, under oath, in several instances, and in the public press, worldwide, has borne false witness against me and my good name, Paul Raymond of the House of Whipple, under oath, for use and in use, in court at Sullivan County Superior and District Court, Newport, New Hampshire, which elements constitute RSA 644-11, criminal defamation, slander, religious persecution, conspiracy to deprive rights, and more. Because when you break our law, which keeps all law, you break all law. And that is what has happened. Under guise of and simulation of lawful and judicial processes. Making such statements without verity, without basis of substantiable fact and evidence, and which did and are causing me to suffer violent assaults, false arrests, and imprisonments, malicious prosecution as a result, the loss of all my rights and more, and which he and they also completely contradicted entirely in testimony sworn Thursday 4/9 at Superior Court in Newport, agreeing on the record with my Paul Raymond's entire account of events that it was peaceful, not aggressive, not violent, and every other thing they've now claimed that is otherwise. Here is evidence of his actual statements, and the town will be required to provide the material basis for every claim they've made. because now they've accused us of being sovereign citizens. They will have to provide a proof of claim for that. They've claimed that this total falsehood, that I claimed on Facebook publicly that I am a warrior of God sent to expunge, this is in quotes, the unholy from the earth, and claimed his and his husband's marriage was an abomination. So they will be required to provide proof of that claim. He says that I said I would return to make sure they were not violating the terms. They will be required to provide proof of these false claims. This is also a 91A request for information of the video of that day. He's making these claims that were on video and with witnesses. He has no basis for them. He says that he tried to ask. How do you try to ask? Do you either ask or not ask? Or is there another thing? I tried to ask. If he was making a formal 91A request, that is not true. Provide the basis for this statement. Provide the video, which will clearly show him trying to ask or not. He said that those lies do not apply. Proof of claim. There's no truth in these things, except down here when he shows that the trooper told him the RSA he wanted to enforce was vague and may not apply to a town clerk tax collector. Repeating that, vague. Obviously, they worked together and found a way to contort it as applying and not being vague, because they arrested me, threw me in jail for 3 days, no phone call, then on an accusation with no basis, material basis, using these inflammatory statements. We have the transcript, we can prove this, that they did agree with us that this was a peaceful, non-aggressive, rebutting everything else he's claimed. Oh, and violent. They say that they now feel threatened at their place of work, and they should not have to deal with threats of violence, perceived or otherwise, which I told the officer, I don't know how that is to be construed other than they shouldn't have to deal with threats of violence, whether they happen or not, perceived or otherwise. Yeah, that's whether they happened or not. But we have the transcripts. This was done under oath, both on written statements and in court, sworn to uphold the under oath. Here is James Kennedy, signature. He's the Superior Court judge. Here's some more of Jim Morgan's statements, claiming that I owe taxes. Oh, and that I'm a sovereign citizen. So they'll provide proof of those claims. He says I was taking out my anger, even though they agreed there was no anger, no hostility, no violence, not even aggressive. Yet they can characterize this publicly to others any way they want. Here's the 235-page compilation of affidavits that the town was served, town of Selectmen, served in hand to Joe Marco by Paul Whipple. This was the served in hand the day before the Croydon Selectmen. I told them we were only a day or two from being in a confirmed constitutional crisis at that time, because the Sullivan County Sheriff, the DA, Mark Hathaway, had already defaulted given 30 days to respond. The sheriff at the time was Simons. He was within 2 or 3 days at the time of defaulting, and it was also served in evidence in a case at Newport District Court. And these are unrebutted, served prior to all of these. So in court, it was put into evidence as if read in full on and for the record here and now, and allowed by Matthew Hogan, the prosecutor, and obviously being already unrebutted and past time to rebut, it was impossible for Daniel Swigert, the judge, to overcome this, but he found a magical way by denying the truth again that I am a man, and claiming that he believes, because they impose their false beliefs and their false religion against us, he believes I am the entity, with no basis of that. And these are the reasons we've taken this action, because these are not courts, these are not law, this is not judicial, this is circus, banana republic, but without the republic. So, the selectmen of Croydon are already in possession and past time to default every single word, term, condition, point of law, point of fact. It stands unrebutted as truth, and they have acted 1,000% in bad faith and against it. So that's a fact. And this was a compilation of work that took 7 years, from 2018 to 25. And they chose to not rebut it, not answer it, because they can't. They can't argue with the truth. They will not go on the record arguing against the truth, but they will act against the truth in other ways, like they did in this most recent event. Now, James Kennedy, what's the date on that? The 10th. So I'll show you this first. Okay. So, the state police refused to accept our report of any crime, civil or criminal or anything. They won't communicate with us. So, we're just going to show the people the facts. Now, first of all, here's the order from James Kennedy based on all their false testimony and hearsay and feelings. He repeats that they claim that I said, oh, and here's the thing. I do have a name. I have a name. I'm a man. Okay? God made men, not the 14th Amendment didn't create men. The government did not create men. Okay? We've all agreed. And the town of Selectmen have agreed I'm a man. I told them my name. It's Paul Raymond. Okay? That's my name, Paul Raymond. I got proof. Now, these people want to contradict that. Look what he does. He was told respectfully, this guy, James Kennedy, he calls him the judge, see? These are administrative tribunals having no authority over man, only their 14th Amendment citizens, or men that consent to be subjected to all these rules and statutes, presumably waiving all inherent birthright first estate, which I have never done, and which that 7 years worth of testimony proves. So I'm going to just go on to this. All right, so I said respectfully, when they start calling me Mr. and all this other crap, I have a name. I'm a man. I know my maker. He lives inside me. He's present in and with me. And what you are doing to me, you are doing to him. That's fact. That's in our scripture. It's in our covenant. They know what they're doing. This is not, that they don't know what they're doing, okay? Again, when you serve them 250 pages for 7 years and they do not rebut a word of it, on the record, when there's time given to rebut, they know what they're doing. Now, respectfully being told I'm a man who has a name, okay? He spends the rest of the time here in this document calling me Raymond. Raymond. That's my name now, Raymond. Raymond, see? That the Raymond. Now I'm the Raymond. I want to show you incompetence, people. It's either incompetence or it's just lawless mockery that they are calling justice or judicial process. And I call it a mockery and contempt. Willful, open, naked contempt for the people. Here's the Raymond. Okay, the Raymond. The petitioner said that Raymond said he would return. See, provide the proof of this. Provide the proof. This is hearsay. This is uncorroborated. That Raymond posted on Facebook that he, Raymond, was a warrior of God sent to expunge the unholy from earth, and that petitioner's marriage to his husband was an abomination. Okay, so provide the proof of these outrageous, religiously inflammatory accusations. And this is in the name of the town of Croydon also. As it says up here, petitioner's husband is planning board president or chairman or whatever it says. So this is in their official capacity also. And the selectmen have acted in their official capacity. So you have the planning board, the selectmen, and the clerk, and tax collector, all having acted in concert, in unison. And they've been asked to provide the constitutional delegation of authority they specifically relied on for every one of these words and acts and claims. Raymond argued. See, I don't argue. God said, do not complain or argue. So I don't complain or argue. If I'm arrested by men with guns and dragged away, what choice do I have but to go, right? I mean, they have shot at me before. They've put 11 bullet holes in my car before. So I know they will resort to pulling the trigger. So that is not an agreement, people. That is not called joinder. They're not going to presume that I willfully went along with all this, that I waived anything of rights or my first estate, which the entire state of New Hampshire is in agreement with, and which they are all in default, past time to rebut. So they're in agreement. So this is all unlawful. Raymond argued that because of this case, this court is conflicted from ruling on the matter. I'll provide photographs if any of this is blurry in the video. But after review, the court finds no conflict. Isn't that amazing? The judge, James Kennedy, he can find no conflict when he is told there's a conflict here involving you. And the reason I bring it up is because it's not the first time it's happened. I'm a witness. I've been auditing these cases for 7 years in both of these courts. We've got probably near 30, at least over 20, 25 probably, cases with stuff like this in them all, people. Okay? So it brings into past what I consider question. I consider every single one of these subject to review, that nothing these courts have done is final and is not lawful. So it should be reviewed in every single case, and every person in New Hampshire, every man and woman who has been run through these courts, so-called, has standing and has claim. We don't have to do complaints. We have claims. Guarantee it. Because these mockeries are in everything they do. I've been witnessing it for years. Here it is, Jim Morgan, the town planning board chair. Okay, so now you got the whole pretty much acting as town government. And you have the people acting in their inherent capacity as the sovereign, who has the right, according to the Constitution, especially when government becomes destructive of these ends, which it has been told it is, and it has agreed, the governor and the Secretary of State. So anyway, Raymond argued there's a conflict involving this court. After review, the court finds no conflict. That's a shocker. Okay? And here he finds a preponderance of the evidence that Raymond stated he would return. There's no evidence of that because it didn't happen, see? So provide proof of that. He says, preponderance of the evidence that Raymond ordered him. And that Raymond stated. Okay? There is no evidence because they made this stuff up. They can provide the video as it's been requested about 8 times. And here, I don't know how you do this, people, but he tried to ask, is this a formal 91A request? I tried to ask. How do you try to ask? You either ask or you don't ask. He didn't ask. This never happened. He made it up. Provide the video and it will show it. Okay? This is all lies, hearsay, that the judge is calling preponderance of evidence. So we want to see that. We need it because it's not evidence. And it certainly can't be preponderance if it's all hearsay and made up. And they don't have no evidentiary basis of it. So, what was the conflict that he finds no conflict? Preponderary evidence that I did put them in imminent danger of great and irreparable damage. See? This is actually what they've all done to me. They have done this to me. They claim I did it to them. There's no material evidence of that. All that they have said is their feelings. See? Feelings. Feelings. Where are the feelings? And this was all raised during the hearing, and he claimed that there was a high threshold that they were asking for, and somehow they met it. The feelings. I feel threatened, and I shouldn't have to deal with threats, perceived or otherwise, right? Whether it happened or not, or if made to feel unsafe in his home. How did he make, okay, so that's feelings, and that's why the statute is vague, because it doesn't cover your feelings, right? You got to provide some hard evidence, not just feelings and accusations. Provide the proof. This is not me saying it. He's claiming I am this, which is just inflammatory, right? And it's a state-created propaganda weapon that he's participating in using against the people. Defaulted, 1,000%. Defaulted. And it's past time to respond. They were all given time to respond. You know when this happened, when this service, the day before, anybody remember what gave rise to Stand Up for Croydon? Remember? The Free State Select Board pulled a little stunt the next day. This was served in hand to Joe Marco, telling him we were on the verge of a constitutional crisis by default of these. And they went out the next day. He said, I can't look at it today because we're all, this was a Friday, we're all preparing for the meeting the next day. And at that meeting the next day, after being told, hey, this is important, we're on the edge of a constitutional crisis, they went out the next day and caused one with the stunt that slashed the school budget and gave rise to Stand Up for Croydon. So thanks for that. Guess where the attention of the town went that day? Not on this, on a brand new constitutional crisis that they gave birth to. All right, so They claim no conflict, and he claims I put them in imminent danger of great and irreparable damage. Okay? Now look at this. Okay, Raymond. It's not my name. He knows it. I said what my name is. This is just a mockery. Raymond. Oh, it was a pattern with Raymond. When I interacted with him, I interacted with him by going in and saying, hey, I'm leaving town for the winter. Do you have anything with me or my name on it? And he looked through his computers. Nothing with your name, Paul Raymond Whipple. Nothing in this building. Nothing in our resources, our computers. These are the two witnesses that went with me to that interaction. I said, good, because I don't want any surprises while I'm away. So that's what I needed to know. Have a nice winter. And I left. So that's all witnessed. And he calls that a pattern. A pattern. Okay, it's a pattern. I went into the building 2 or 3 times in my life. That's a pattern. Now, look at this. Okay, therefore, as stated on the record, April 9 hearing for a 3-month period starting today, April 9, 2026, Raymond is ordered not to harass, threaten, intimidate, or interfere with the liberty of the petitioner. This restraining order shall remain in effect until July 9, 2026. Now I asked, where's the statute for this, feelings? So I know I don't want their feelings to get hurt while I have to defend myself, and then I'm in jail again, right? Where's the statute that gives me the safety so I know what behavior to, okay? So 90 days, I can't harass, threaten, intimidate, or interfere with their liberty. Now, this remains in effect until July 9, 2026. Unless a motion to extend is filed on or before July 9, 2002. Okay? 202, which was, 1,820 years ago or so. This matter shall be dismissed on July 10, 2066. Okay? So, here is a 90-day, 3-month, so it's not 90 days, it's 3 months. Starting today, April 9, 2026. Remaining in effect until July 9, 2026. However, on or before July 9 of the year 202, this matter shall be dismissed on July 10, 2066. Okay, so they have 1,864 years to respond or not to this 3-month issue. And this was vacated against David Aubrey. So, there's the signature of this man who enjoys calling me Raymond, and who does this kind of mockery, year 202, year 2066, Raymond, and repeating all the false accusations as though they were true, and calling it preponderance of evidence. Now I want to show you the conflict that he says doesn't exist. Okay? This is notice I served to the governor, which she acknowledged receipt. I've been serving them for, like I said, over 7 years. 2 administrations. We get acknowledgments of receipt. In this case, we notified them that we, the people of New Hampshire, are suing the state of New Hampshire for gross cause. I mean, the town, the select board, on July 23rd, I believe, the same day they recognized and agreed I'm a man, which means I was created by the Creator, and is a beneficiary of the Declaration of Independence indenture, trust indenture, having no waived any rights ever, and one who walks with God, and God indwells according to the covenant. Secretary of State David Scanlon has issued a acknowledgement of receipt and has opened a file for this matter, which is our suit against the state, in our capacity and our inherent authority. Okay, we're not using the bar, we're suing the bar and the state. Stephen P. Girdwood, attorney, received service for the bar and has since been either disbarred or can't practice because he's the one that started the frivolous lawsuit against us and then was booted, so they got another attorney who just perjured himself 2 weeks ago. We have evidence. So this was to notify the governor of what her attorney general was doing. And latest development in the state of the people's plight under your watch. Malicious prosecution by the state of New Hampshire and others. This is ongoing for 11 years, people. 11 years. It's gross negligence, gross malpractice. Just, you will not believe it, but we have all the records. Now, this is evidence involving James Kennedy. See these words? Due to judicial conflict involving James Kennedy. He says, no conflict. Well, I didn't make this up. What happened? The New Hampshire Attorney General's Office, New Hampshire DES and staff against the people. Thankfully, within days, this office received notice that Attorney General had reversed course, withdrawn an illicit and void default judgment gained by the Attorney General from Sullivan County Superior Court Judge James Kennedy. He says there's no conflict. These are undisputed facts. Here's the letter. Here's the proof. Here's Cheshire County. Why is it Cheshire? Because it was taken from Kennedy due to a conflict with the presiding Sullivan County judge, James Kennedy. So said by Ann Edwards. And that finally all filings shall be filed with Cheshire County Superior Court, Cheshire Clerk, which is the same clerk and the same judge. They just moved all the records and the proceedings to Cheshire. So no documents can be filed with the Sullivan County Superior Court Clerk's office. So, what did the Attorney General do after that fact? Now here I am recognized as a non-attorney and a representative. So, they have obstructed justice, arresting a process server, a representative of the people. Now, here is the Attorney General's letter saying, hey, geez, you know what happened? I went to Sullivan County to get a default judgment against you for $25,000 because it's easy to do, you know. What do you need, buddy? Here's a rubber stamp. Even though the case wasn't in Sullivan County because of conflict. So it was taken away from James Kennedy in Sullivan County, given to Ann Edwards, and then moved to Cheshire County, so nothing could be done in Sullivan County. Nevertheless, the Attorney General, you think he would know how these things work, he went to Sullivan County Superior Court and got a default judgment from James Kennedy, which then, right here, Sullivan County Superior Court issued a final judgment, though the case was not in his county or his court, because of conflict. Because of conflict with the presiding judge. The new attorney of the frivolous lawsuit, in the last court session, claimed that due to a conflict caused by one of the people. That is not what it says. The conflict is with the judge. The Sullivan County Superior Court issued a judgment against you when it had no case and had no authority even in the county, because it had been transferred to Cheshire County via order dated August 19th. The state never received a copy of that order. Okay, so the Attorney General is going to play dumb. Oh, we didn't know. So we're tearing it up and we're starting over. Good, now he has to prove every claim because he got away with a default before. And every claim he's made is frivolous and fraudulent and defamatory. So that'll be exciting once he finally does file and puts his name and his seal on another packet of lies. Now, here we go. Well, I think that's pretty much it. So that's what is going for law and judicial process, while the defaulted town of Croydon government calls our lawful due process a simulated legal process. Look at that, 25 grand. 25 grand this guy wanted to charge people based on lies, and they're the victims. They're the victims, people. This is what is passing as justice in this state. And the whole thing is corrupt, top to bottom. We've got 7 years of this. And we will be presenting it to the people of New Hampshire, the people of Sullivan County, for a jury to judge. That is our right, according to the law of God and nature and the constitutions of New Hampshire and the United States. As well, our perpetual union, which is prior, superior, and founded on the truth, the light of the blessed gospel. We have all these things in evidence. You judge that for yourself if you want to call this integrity. And so what happened, Judge Kennedy was told way back of a conflict. He said he found no conflict when it was first raised. It was raised. Kennedy said he found no conflict. So he has a habit and a pattern of finding no conflict when it involves him. But then others, meaning the Superior Court Chief Justice of New Hampshire, found the conflict involving Kennedy and removed all cases from him. So he found no conflict. He was overruled and everything was taken away from him. The Attorney General then went to Kennedy, who had no case and no authority, and gave a default judgment. Severe judgment, $25,000 to a victim. Okay. Granted. So I raised the conflict again with the governor. The AG rescinded and refiled. Well, he said he's going to refile. We haven't had notice of that. And if he's wise, he won't, because then he will have defamed them, and there's no chance of a default this time. He will have to defend every word that he claims. Kennedy claimed in court that day, this is April 9th, a week ago, that he wasn't familiar with this. Well, that's under oath in court. After I raised it, he claims there was no conflict. Okay? So, we're reporting this to the Supreme Court and to the United States Attorney and whoever else we have to, because this is not going to stand. This is what it is, and it is not anything else. So, he has a habit of claiming impartiality when there is no evidence of impartiality, but overwhelming evidence to the contrary. Okay? So that's just one example. We have many, and we'll be showing you. I mentioned one with Swigert imposing his false beliefs that I am an entity. That's their 14th Amendment citizen, which is all rebutted and actually in court, in their evidence. So that thing that the state created is out of business and is in court, in a folder, in evidence, and the town of Croydon is claiming that it's out running around buying land. So I can't wait for them to provide the evidence of that. How'd it get out of the custody of the court? And now the court that's presuming to judge it has to overcome that as well. So when I go back to this picture, of all the stuff they've defaulted to, this all began way back in 2018 with a writ of quo warranto, which is by what warrant, asked the judge Cardello, who's now enjoying his peaceful retirement after plundering the people of Sullivan County for a career. And I have the evidence that on that day, I appeared, rebutted his claims, and got the transcript, got the audio, got the witness. All that says I was there and I was talking, and here's words attributed to Paul Whipple. Nevertheless, Cardello sends a notice to the DMV that Paul Whipple failed to appear. Okay? I have the proof. So this is the clown show that these guys get away with. And you wonder why? You can look up 2013 NHHB, that's New Hampshire House Bill 638, which tells you the condition of this thing posing as a government is a completely unconstitutional and lawless regime, a legal system of usurpation of all three branches of government by the bar after removing our original 13th Amendment, which forbid titles of nobility from holding any office of trust in the United States or any of them. And now they're almost every office is in breach of trust because of the bar and its army of attorneys that call this justice. This, Raymond. You have from the year 202 to 2066 to respond to this 3-month period. Okay? Well, how do you judge it, people? This is how they conduct business in the name of the law. And that's why we've taken the action we've taken according to our rights and upholding our rights and our peace, which is the gift of our Creator to us, who said, "My peace I give to you." All right, so God bless. We'll talk with you soon.